jump in. Welcome to Trademarks 101. It's a primer on all things trademark. So before we get in, I'm just going to kind of welcome everyone. Thank you for coming tonight. We're just going to spend some time together throughout the month of March. March is Women's History Month. So I just really want to do the webinar to educate, empower, and embolden women to take charge of their brands as business owners. So we'll have a series of free webinars throughout the month. But our first one is today on March 9th. This is Thursday. Each webinar is going to be on Thursday. And the objective of today's webinar is really just to help you understand trademarks and start to consider how you can use trademarks to build value for your brand. So who am I? My name is Curleen Jean-Louis. I'm a Massachusetts native, born in Boston, Massachusetts, raised in Somerville, Massachusetts, still live in Massachusetts, have been in Massachusetts my whole life. I'm a first-generation Haitian American woman. My parents immigrated here from Haiti in the early 80s and definitely left everything they knew to start a better life for me and my siblings. I'm forever indebted to them. I'm a serial entrepreneur, founder of the KJL law firm PLLC. I'm a licensed attorney. I'm licensed to practice in the states of New York and Massachusetts, and I've been licensed as an attorney for over 10 years. Before I started serving brands, businesses, creatives, and nonprofits in the brand protection and trademark sphere, I was a litigator, so I was representing traditionally underserved groups in court here in Massachusetts. As a litigator, I was selected to participate in the National Institute of Trial Advocacy's Trial Building Skills in Washington, D.C. in 2019. And as I stated, I transitioned to serving businesses and brands as I myself became a brand owner and started building my own businesses. I realized people who came from my community, people who looked like me, didn't necessarily have access to the tools necessary to make sure that they laid a solid and strong foundation for their brand. So I pivoted and started representing people who came from where I come from and looked like me. And so I am admitted, like I said, in Massachusetts and New York, but I serve trademark clients nationwide because, as you'll soon learn, it's a federal right for individuals who register with the USPTO. Okay. Overview. What's our goal for today? I just want to give you a broad overview, an eagle's eyes view of what trademarks are, because a lot of times people do not know what trademarks are, or they may kind of think they know about it. So I'm going to briefly explain what trademarks are. Trademarks are a type of intellectual property. So I'll give a very, very brief overview of what is intellectual property, what are the different types of intellectual property. Maybe you actually hold more than one type of intellectual property in the course of you running your business and or brand or nonprofit. So we'll kind of lightly touch on the different types of intellectual property. Then we'll discuss what is a trademark, why are trademarks important, what can you actually trademark, what's eligible for registration on the Federal Trademark Register, some common misconceptions about trademarks, some things people think but may not necessarily be true, and then we'll discuss choosing a trademark, selecting a mark, and tips for you to utilize when selecting a trademark. So what exactly is intellectual property or IP? You sometimes hear people refer to IP, intellectual property as IP. It's just a shorthand way of saying intellectual property. Intellectual property refers to the creations of the mind. So if you think of property, there's typically two types: real property. So real property is your home. You own your home. It's physical. It's tangible. You can touch and feel it if you're a homeowner. Intellectual property refers to your creative ideas, the things that you come to think of in your mind. So that's just what intellectual property is. It belongs to you, just like your home belongs to you, but your home is a physical, tangible thing, and your intellectual property, your creative ideas are not tangible. They're intellectual. They come from your mind. So that's why they call it intellectual property. What are the different types of IP? There are three main types of IP: copyrights, patents, and trademarks. And copyrights are what the law says or the statute says are original works of authorship. So think about writing a book. Think about choreographing. Even if you choreograph dances, that is copyrightable. If you have a website, the information that you've created that are original, that means you didn't take it from someone else. You created it. those original works of authorship. So that is protected by copyright. If you notice on the bottom of my slides, I have copyright 2023, KJL Law Firm, all rights reserved. A fun fact about copyrights is that as soon as you take that idea of that book and put it in a tangible medium, is what they say. You can't say, well, I have a book idea in my head, and so that's copyrightable. No, you have to take that idea and put the pen to paper, so to speak. If you choreograph a dance, it can't just live in your head. You have to express it in some type of tangible form or medium. But as soon as you do that, you have a copyright. However, in order to enforce your rights, you have to register your copyright with the copyright register. So that's something to think of. Maybe you are an author and you want to get a copyright for your book. As soon as you write that book, copyright exists, but in order to protect it and defend it from other people, you have to register that copyright. And so copyrights focus on a brand's messaging. Like I said, your website content, you can copyright. It's wise to put copyright, when you created it through present date, the name of the brand, all rights reserved. If you have marketing materials for your business, your brand, your nonprofit, you can as well put that at the bottom, and you don't have to register it. It's just a quick way to protect it. But if you want to enforce your rights, it's very wise to register copyrights. And so copyrights are limited in term, but it's a long term. It lasts for the life of the author plus 70 years. So I'm not sure if you hear sometimes they're like, well, this year in this year, these certain works are going into the public domain. So when they go into the public domain, it's like famous books like Winnie the Pooh and things of that nature that were protected by copyright, but the copyright has expired because the life of the author plus the 70 years has passed. And so those things go into the public domain. And if you think about moves and things of that nature, people can begin to use the works without infringing on that person's copyright. So another cool thing about copyrights is that you have the right to derivative works. And that just means that if you have a copyright to a book, you also have the rights to create the movie to that book, et cetera, et cetera. So something that Reese Witherspoon, I'm not sure if you know, she has a book club. She's very wise. She picks these books. She says to the author, hey, is it okay if I get the rights to your movie? So the author, I'm not sure, sells the rights or licenses the rights. She makes these movies where she's producing it, she's acting in it, and she has her book club. And so she has like 2 million people, I think, in her book club. So she's also helping these authors because they're getting 2 million sales in books. So very, very strategic way of her not holding the copyright herself, but working with people who hold copyrights to certain works to take those books and then making them into movies. Patents, on the other hand, are for inventions typically. You can think of new technology, new software. Those things are patentable. If you have, there's different types of patents. I'm not going to get into them, but the most common is a design patent. So if you design something that's novel, you can seek to patent that. And so for a patent, it has to be novel, which means new. You can't take something that's been around and try to patent that. That's not how it works. It has to be novel or new, non-obvious, which means you can't just take something that's clear to everyone and say, hey, I'd like to patent this. You have to kind of come up with something, be a little creative and useful. It has to have some form of utility. And a patent lasts 20 years from the date of the application. So more limited in term, but the thing with a patent is technically you can file for a patent, get the patent registered and not have to use it. Whereas as we transition now into trademarks, trademark rights are acquired through use. And we're going to talk about that a little bit more further in the webinar, but trademark rights are acquired through use. So trademarks protect a company's messaging or focus more so on a company's, it's all about branding and marketing. So trademarks protect words, phrases, symbols, logos, etc. And the difference between trademarks and these two other types of IP that I referred to is that trademarks have the ability to last forever. So if you think about a McDonald's, if you think about a Coca-Cola, Coca-Cola has been around for years, decades. I want to say 1900s, but I can't pin that. So I'll just say years and decades. Trademarks have the ability to last forever if you properly maintain your mark. And we'll talk about that more later. So what exactly is a trademark? I touched upon it lightly, but let's dive, let's take a deep dive into it now that we covered the different types of IP. There's another type of IP that I didn't throw in there, trade secret. Trade secret is basically a company secret that's not, it's think of KFC's Colonel's recipe. That recipe is a secret for that company. They protect it. So if you have a trade secret, you have to go through great lengths to show that this is a secret to your company, and you guys go out of your way to protect it. Think about McDonald's mac sauce. Only a few people, if you're trying to kind of prove that you have a trade secret, only a few people in the company should really know the recipe. It should be locked away in a secure place where, people with maybe only the top or the highest clearance in the company can actually enter and access it. So that's a trade secret. I didn't really delve into that, but that's another form of IP. But going back to trademarks, this is from the trademark statute. I'm going to read it, but then we'll talk about it in plain English in a little bit. So the term trademark includes any word, name, symbol, or device, or any combination thereof to identify and distinguish goods, including a unique product, from those manufactured or sold by others, and to indicate the source of the goods, even if that source is unknown. What does that mean? And if you didn't catch all that, that's okay. If you're registered, you will obtain a copy of the replay. The replay will be available for you if you want to take notes at your own pace at a later time. In plain terms, a trademark is a word, a phrase, a symbol, or a logo, or any combination of these things used to identify and distinguish a brand. So a trademark really is a source indicator. If you think of the red sole under a shoe, if I walked into the room or you walked into the room and you saw me wearing a pair of shoes and underneath the shoe you saw the red sole, if you want to let me know in the chat, do you think you would be able to tell where I got those shoes from? If I walked into a room and you saw me wearing a pair of shoes and I had a red sole underneath the shoes, if you think you would be able to tell, you would know where I got the shoes from, that means that red sole serves as a source indicator. We all know it's Louboutin, right? Louboutin is famous for its red logo, well, red sole underneath the shoe, which is a trademark, because as soon as you look at that pair of shoes, you know that comes from Louboutin. If I'm passing by a fast food restaurant and I see the golden arches, I automatically know that the food from there is from McDonald's. So trademarks serve as source indicators. They're kind of the reputation of a brand. If a brand has a great reputation, like if you see a bag with, LV logos all over it, you think of Louis Vuitton, and that reminds you of luxury and quality. People are willing to pay a lot of money for it because the brand has a reputation for high quality and for good quality bags and other goods. So a trademark is a brand's reputation and it's a brand's goodwill. It's kind of a shortcut because all those brands have put in so much work into marketing that as soon as I see the trademark, I automatically know the brand, I trust the brand, and I'm willing to do business with the brand. So again, a trademark is a word, phrase, symbol, logo, anything used to identify and distinguish a brand. It serves as a source indicator. So it basically allows the consumer to tell your brand from other brands, and it also protects the consumer from marketplace confusion. Because if anybody was just allowed, if the red sole under a Louboutin shoe was not trademarked, that means people wouldn't know whether the shoe they're trying to buy is a Louboutin shoe or a lesser quality shoe. So it really is to protect the consumers from confusion and also to distinguish your brand from other brands. Why are trademarks important? Trademarks are important. Oh, trademarks are important. Who needs a trademark? That's the wrong slide. I'm sorry, y'all. Here we go. Why are trademarks important? Trademarks are important because they can be a company's most valuable asset. If you do a quick Google search, there's an annual report that comes out, the 100 most valuable brands. At the top of that brand, the most recent one, I believe, is Apple. Go to uspto.gov, search in, and look up how many trademarks Apple has. Apple may have a lot of patents, Apple may have copyright, but Apple's trademarks, I bet, far exceed the number of other intellectual property that they hold, because trademarks are a company's most valuable asset. They're kind of how the public perceives their brand and receives their brand. So trademarks can be among a company's most valuable assets for these reasons. They add value to your brand. They're helpful when seeking investment for any new startup, company, or business, even for the nonprofits. The nonprofits, we're not going to let them we're not going to let them go, because nonprofits, trademarks are very important for nonprofits too. If you think about Red Cross, that's a nonprofit that has a trademark. If you think about a college, I went to Boston College. Boston College has registered trademarks. They're considered a nonprofit. So just because you may not be offering at a profit doesn't mean that your brand doesn't need protection. It's still a brand. Trademarks are important because they add value to your brand. Imagine you have a brand and you're looking for investors to invest in your business. Well, they're not going to feel comfortable investing in your business if you don't have a trademark, because someone may pop out of the woodworks later on and say, hey, you're infringing on their brand. And then you may get a cease and desist. You may get an infringement suit on your hands, and those investors' money that they put into your business is not sure. Investors like a sure return on their investment. So it helps to put investors and others at ease when they're investing in your new startup or your new business. It also allows you to generate money. If you have a trademark, you're able to license that trademark to others. You're able to say, hey, in this circumstance, we're going to come up with an agreement, and this person's going to pay me X amount of dollars to use my trademark or the brand name. So say maybe you are putting together a series of workshops, and you have a trademark for your workshop name, your brand name, and someone comes along and says, hey, I love what you're doing. I'd like to do workshops too. I don't want to infringe on your brand, but I kind of want to be connected to it. You could license the use of that mark. And also, if you later on decide to sell your business, you are able to also sell that trademark, so you can get a lot of money in the event that for whatever reason you might be exiting the business. You can sell your rights to your trademark and assign that trademark to someone else for a dollar amount and make money as well. And if you know or don't know, maybe you have some products you'd like to sell on the Amazon marketplace. In the future, Amazon requires you to have a trademark on the principal register. Trademarks are also helpful when you're enforcing your rights, when you're suing infringers. Just like I said with copyrights, trademarks rights, you acquire them when you start using them. However, if you want to take somebody to federal court for infringing on your right, you would need to have a registered trademark. It would be way more helpful when you're making your case, because when you have a registration, it's presumptive owner. It shows that you're the presumptive owner of the mark. It can help you combat counterfeiters. If someone is selling stuff with your brand name on it that you're not selling, you can maybe go to Etsy.com and say, hey, here's my registration. This person's infringing on my trademark rights. You need to, shut down their Etsy store, or whatever. It's helpful when you're issuing cease and desist letters. If someone's using your brand and you have not authorized them to do so, when you send that cease and desist letter and say, hey, I have a registered mark with the USPTO, which means you should be on notice because it's listed in the USPTO database. It's helpful. And then also for social media infringers, and even for cyber squatters, people who might take your domain name, you can go through ICANN. There's a process where if you have registration, they will take it down for you, and it helps streamline that. So yes, it can be a company's most valuable asset. Who needs a trademark? Any business, brand owner, entrepreneur, and or creative. I'm thinking about artists. I'm thinking about singers. I'm thinking about small business owners, anyone, nonprofit organizations, anyone who's selling his or her products and or doing business in more than one state. And at this time, in this day and age, that's most everyone, because of the internet, because of social media, because of the way we market our brands and businesses now. You're most likely not just doing business in the state where you're located or the principal place of business for your business or brand. So if you are moving across state lines, it's really advisable, it's really wise to make sure you get that protection, that nationwide protection. I do have to say, although I'm a trademark attorney and I'm providing some information about trademarks, all this information is for educational purposes only. You shouldn't take it as legal advice because I don't know the specific facts of your case. If you do have a question, you can definitely schedule a consultation or contact a local attorney. What can I trademark? Some people don't know what they can trademark. They're like, hey, I have this great idea, but I don't know if I can trademark this great idea. Well, let's just go over some of the things that you can actually trademark. Words, logos, stylized lettering, that fancy writing on the Coca-Cola bottle, Netflix, the way they write Netflix in that red script, that stylized lettering, sounds, the MGM lines were at the beginning of their movies is trademarked, scents. Play-Doh actually has a trademark for the smell of their clay dough. Tactile, if it's distinguishing enough, if it's a source indicator, you could register a trademark for the feel of something. That's not too popular, but a wine company has registered trademark for the feel of their wine label. Color, as I said, the Louboutin Soul is trademarked in the United States of America. And trade dress, if your store or a restaurant has a certain look or design or feel that's not functional, you can actually register that as a trademark. And the interior design of Apple stores are actually registered as a trademark. So that's a little crazy. You can trademark a lot of things, a variety of things, and any combination of this. So if you have words with the logo, you can do that. If you have stylized lettering with something else, you can do that. So like I said, like I mentioned earlier, it's a combination of any of these things. So if you have a tagline for your business, you can do that. If you have a slogan for your business, you can do that. What I see people do most often that they don't realize is not effective is that they might have a great phrase and they put it on a t-shirt and then they file for federal registration. And when you file for federal registration, you have to show a specimen of the mark. And so they'll submit that specimen. But in the eyes of the USPTO and per the trademark laws, just putting a phrase on a t-shirt does not serve as a source indicator. Most often is the label on the tag on the t-shirt. That's the source indicator. That's what tells you where the t-shirt is from. So if my brand name is Happy Days, I should have Happy Days on the tag in the t-shirt, even if I'm going to put Happy Days on the front of the t-shirt, because Happy Days is supposed to serve as a source indicator. And people are like, okay, I looked at the tag. This shirt is from Happy Days. I think Happy Days is a great brand. I'm going to buy this t-shirt. So that's just something to consider, because a lot of people get tripped up when they're filing in class 25 for clothing. So it has to function. They say function as a trademark. And if you just have the logo on the front of the shirt, that's what they'll describe as ornamental. So they say you're just using it as a, an ornament, as a decoration. It's not really functioning as a trademark. It's not really serving as a source indicator. It's not really working to distinguish your brand or your goods and or your services from another brand's goods and services. Common misconceptions. So people sometimes say, hey, I filed for an LLC. I've incorporated as an LLC in my state or another state, and they think they're all set. But incorporating an LLC in your state and or another state, the principal place of business for your business, does not automatically give you federal trademark rights. What that incorporation is, just you forming a legal business entity, which is excellent and amazing, which you should do. But it just says that that name is okay for you to do business in your state. That does not mean that you will get trademark rights, because you may conduct a search and see someone else is using that name and has already secured federal trademark rights for their brand with that name. I had a case myself where I was working with someone and they said, hey, I already obtained a domain name. So they thought the name was cleared. And I did a quick search and I said, you might want to, search for another name, because the domain name is clear. But I did a quick look and someone has registered rights and it's still in use. It's still active. And so just because the domain name is clear does not mean that you can do that, because that person, even if they don't have the domain name, can come later on and say, hey, you're infringing on our rights because we have rights for that name as it relates to these products or services, and can shut your business down. So it's great to do your due diligence to check and see if the handles, the social handles are available, to check and see if the domain names are available. But that alone does not mean that you're in the clear as concerns federal trademark rights. And also, you could be unintentionally. I guess all I'm saying to this is it's great to do your LLC. It's great to snag a domain name, but you may be unaware that you're actually infringing on someone else's rights. So you may potentially be infringing on someone else's rights. That's why it's important to make sure that you secure your trademark rights and get, your ducks in order, so to speak, before you move forward with building your brand. All right, choosing a trademark. We're already here. Choosing a trademark is a very, very important process. Let me stay here. And there's a spectrum. There's a spectrum of weak marks and to strong marks. And so when you're choosing a mark, you have to ask yourself, or this is kind of an analysis that's going to be done if you hire an attorney. Is the mark protectable, which means can I stop others from using it? And is the mark available, meaning can someone else stop me from using it? And there are two things. You have to think about, not only can I use this mark, but can this mark actually be registered? And before actually I go to choosing a mark, let me just skip down. Benefits. So some people say, why should I file for federal trademark registration? There are a number of reasons why you should file for federal trademark registration. As I stated earlier, if you are using your mark, you're already acquiring rights, because trademark rights are acquired through use. That's why if you file with the USPTO, you have to choose among several there's a few filing bases, but the two most frequently used, especially if you're in the US and starting a business in the US, is a use-based application and an intent to use-based application. Why is use involved in both? Because trademark rights are acquired through use. That's how the law is set up. So for a use-based application, you're already saying I'm using the mark in commerce. I've already launched my store. I have a sign. I'm selling cupcakes to everyone, and I'm using this name. That's a use-based application. For intent to use application, you're saying I haven't launched my store yet. I'm not selling my cupcakes yet, but I have this idea. I have this great name, and I want to file even before I get started, because I want to make sure I protect my rights. It might take some time for me to get started and get going, but I want to make sure I protect my rights and I lock this name in so I can prevent other people from using it later. And, basically having the carpet kind of, slipped out from under your feet because someone else is using something that you had and they got to it first. Going back a little bit, when you use trademark rights, when you use your trademark, you get rights. But if you're doing that, that's what's called common law rights. So if you are just using your mark, say I live in Massachusetts and I'm selling cupcakes, and I'm just selling cupcakes in Massachusetts and Boston, and I don't use the internet, I'm not selling cupcakes online. Even though I'm using the mark, if I don't register it, I only have rights in Massachusetts. So in the territory I'm in, I only have rights in Boston, Massachusetts, and then what they call the natural zone of expansion. So if it's like, okay, I'm selling cupcakes in Boston, I mean, maybe I can later sell cupcakes in Stoughton. Maybe I can later sell cupcakes in Newton. Maybe I can later sell cupcakes in Lawrence. Maybe I can later sell cupcakes in Lynn. So that might be my natural zone of expansion, might be Massachusetts, maybe Rhode Island, maybe, other, maybe New Hampshire. But that's it. That's if you don't register. If you file for federal trademark registration, you not only get the rights where you're at, you get nationwide rights. So that means that someone in California cannot later come and say, hey, I want to use the name Susie's Cupcakes is not a good example. I want to come and use the name Delicious Delights. No, actually, because I filed for federal trademark registration, I can prevent that individual from using Delicious Delights for their cupcake business, because I've done it on a nationwide or a national level, versus if I just use my common law rights, I can only stop that person from doing it in Massachusetts. But if they file for federal registration, they'll be free for California and everywhere else, if that makes sense. So that's one of the major benefits of filing and registering your trademark with the USPTO, because you get that protection. There's also state registration. state trademark law registration that you can, or state trademark registration, but that's not really something that many people do because many people don't really get a benefit from it. It's only helpful if maybe if you think about the cannabis industry, it's not legal on a federal level, but at least here in Massachusetts, it is legal. So you can maybe file for a state trademark registration for cannabis business because it's not legal yet. And if something's not legal, you cannot file for registration at the USPTO, at least on a national level. So that in that case, maybe you can just preserve your rights, and then when eventually it's legalized on a national level, you can file for registration with the USPTO. But generally, people do not do state trademark registration because it's not really helpful in a lot of cases. So again, benefits of trademark registration. I can use it nationwide. I can use my mark nationwide. I can protect my mark nationwide. So if I'm selling delightful treats or delicious delights over here in Massachusetts and someone attempts to use it in California, I send a cease and desist. They don't really listen. They continue infringing on my brand. Then I can take them to federal court and enforce my right there. And you can get statutory damages in some cases and even get attorney's fees in some cases. So that's an important reason. So it's a presumption of ownership. There's a legal presumption that you are the owner of the mark because it's registered on a federal level. But one caveat is that common law rights do supersede registration. So even if you have your registration, that's why it's important to do a search. And if you work with an attorney, they're going to make sure they're going to do a search to make sure there's not someone else with prior common law rights, because that could affect your rights, even if you registered at the USPTO. Your mark is listed in the USPTO database. So if someone's acting in good faith and building their brand, they'll go and type in your brand name and say, hey, that's not available because person X is already using it. So it's listed in the USPTO database. If you're selling goods, you actually can register or record your registration with the U.S. Customs and Border Patrol agency. So that way, if you are, a luxury handbag designer, we're speaking into existence. If you're a luxury handbag designer in the future, and your bags are just so popular, maybe people are going to try to counterfeit that and bring it in the country. If you record your registration with the United States Customs and Border Patrol, they can actually prevent the infringers from coming into the country with your goods, and they'll seize it and eventually destroy it if you have a federal registration. So that's good as well. If you plan on expanding your business to other countries, you can use your U.S. Federal trademark registration as a basis for filing in other countries and get the filing date of your U.S. registration. So that's a very good benefit as well. And you get to use the registered trademark symbol that are there. You get to use that. If someone does not have a federal trademark registration and they're using that, that's fraud. In the interim, before you file or before you get your registration, if you're filing, the trademark filing process is lengthy because there's so many people filing right now because there's so many people launching businesses. So they have a backlog. You can use the TM in the interim, but you can only use the registered R symbol when you have federal registration. And if you want to sell on Amazon, it's required because oftentimes when you are infringing on someone's mark, those people obviously know Amazon has more money than you, so they go after Amazon, and Amazon can be potentially held liable for basically facilitating the infringement of that person's mark. So Amazon requires sellers to have federal trademark registration, and it has to be on the principal register, not the supplemental register. Okay. So choosing a trademark. I'm not sure if you already have a brand name in mind or if you're thinking of a brand name, but if you haven't gotten there yet, or if you have a brand name, I just want to talk about selecting a mark, because oftentimes people do missteps at this step. Choosing a strong mark is very helpful in ensuring the success of your application. Because if you think about it, if your mark is not strong, that means you're not the only person who has thought of that name, and there could be a number of people who have thought of that name. So you can be infringing on someone else's mark. That mark may already be taken, or you will get a very limited scope of protection. So there are several types of marks, and they go from weakest to strongest. So you have generic marks, you have descriptive marks, you have suggestive marks, you have arbitrary marks, and you have fanciful marks. And just to explain, we'll start with fanciful. So fanciful and arbitrary are the two marks that you will, when I say mark, I'm talking about trademark, are the two marks that have the strongest protection. So fanciful marks are words that are made up and literally have no meaning. So if you think about Exxon for gas, Exxon Mobil, Exxon is a made up word with no meaning. Someone just made it up. And so that's a very strong mark, and it has a very strong scope of protection. If you think about Kodak, like for film and things of that nature, not Kodak Black, the artist, but Kodak is a made up word that had no meaning, that was fanciful, and that is a very strong mark as well. If an arbitrary mark is also strong, it's a word that has some type of meaning in the English language or in language. However, when you connect it with the product or service that you're selling, it doesn't really mean anything. Think about Apple for computer products, software products, watches, things of that nature. Another arbitrary name is Virgin for the airlines, Virgin Airlines, Virgin Records. It means something, but if you think about airplanes, you're not really going to associate it with the word Virgin. If you think about Kind bars and things of that nature, they're protein bars, they're health bars. You're not going to really associate the word kind with it, although kind does have a meaning. It's arbitrary when it's in connection with the product, which is a food bar, or a health bar, a healthy food bar. Suggestive is a mark that kind of tells you what the product is about, but isn't really stated out. And so it's not a weak mark. It's not as strong as fanciful and arbitrary, but it does have a broader scope of protection than descriptive and generic marks. And so if you think about Copper Tone, it's a suntan lotion. It's supposed to make your skin more tan. So Copper Tone, suggestive. It's kind of straddling the line, not the strongest, but it still will get you on the principal register. Descriptive marks are marks that convey an idea or an aspect of the product or service. So for a descriptive mark, think of course, my mind's going blank right now. Say if I was selling a phone and it was like smartphone, you could even say is generic now, but that would be descriptive. It would convey an aspect of, an advanced phone or something like that. And smartphone is kind of getting too generic, but a descriptive mark has to acquire secondary meaning, which means that you have to, it has to get a degree of, basically you have to attach another meaning for it to become a trademark. It has to acquire distinctiveness, they say. And descriptive marks are not going to be on the principal register. They're going to be on the supplemental register. When you register for a trademark, there's two registers. There's a principal register, which is the main register, which gets all of the protections that I listed earlier. And I forgot to add, for the principal register, after 5 years, if you show continuous use after 5 years, in between years 5 and 6, you can file for what's called incontestability, which basically means that it's going to be very difficult for you to lose your trademark rights unless you abandon your rights, which means you don't do the maintenance filings, or you something called genericide, which doesn't typically happen in the small businesses, but it can. For example, Band-Aid, I'm not saying genericide has happened to it yet, but Band-Aid, if you think about it, it's supposed to be a Band-Aid brand bandage, but people don't call them bandages really. They call Band-Aid, so let me get a Band-Aid. Band-Aid is a registered trademark. Trademarks are adjectives, so trademarks should be describing something. So when you start to refer to trademarks as nouns, that's something that in the trademark world we call genericide. It starts to lose its meaning. It starts to lose its distinctiveness. And if you don't enforce your trademark rights, you can lose them. So a lot of brands have lost their trademark rights because they don't enforce them. That's why sometimes people think it's mean when people send cease and desist letters, but if you don't police your mark and let everyone use it, you're gonna lose your trademark rights. So it's not wise to do that. You definitely want to protect your rights. You have to get trademark rights, and then when you get them, it doesn't just stop there. You have to police your trademark rights. You have to enforce your trademark rights. Um, and so Band-Aid is kind of generic now. Escalator used to be a registered trademark, but has lost its meaning because everyone calls, I don't even know what it's called. Everyone calls that an escalator. Velcro has done a good job of preventing their brand from becoming generic because they do a lot of education and they call it, the Velcro brand of shoe fasteners, because I guess technically it's a shoe fastener and Velcro is a brand name. So that's why it's important to come up with arbitrary and fanciful marks so people don't go ahead and make your mark generic. Generic, I even put it here. Generic is an apple for apple. If you're selling apples and you call your brand Apple, that's generic. If you're selling bundles and you call it, hair store, that's generic. That's not protected. You can call your store whatever you want, but you're not. If you try to file for federal registration at the USPTO, the United States Patent and Trademark Office, you are not going to get any protection because that is very, very generic. Okay. Let me just make sure I went through everything. All right. So that, in a nutshell, is a primer on trademarks. If you have questions, please drop them in the chat, and I would love to answer them for you. Maybe I missed something. I'm kind of used to doing this, so maybe I went over things and you have some questions, or maybe you want further information. As I said, this is a webinar series. So today we're touching on trademarks. Next week is protect your bright ideas, and we're going to go more into the mechanics and function of actually filing for trademark registration. I mentioned a couple of things: intent to use, the principal register, the supplemental register. We're going to go more into the mechanics of, if you're trying to file an application, these are some of the things you should look out for, and these are some of the things you should do. And I'll give you guys just a couple of minutes if you have a question to drop it in here. If you want, please feel free to reach out to me on social media and let me know if this was helpful or not helpful. Give me some thoughts for room for improvement. I'm always open to bettering what I do because I'm here for you, and I want to definitely serve as a resource and add value to your life and what you do. I know we're all busy, and you're taking your time out to be here tonight. So I definitely do not take that lightly. And I definitely thank you for joining, and I appreciate you joining. Okay, if there's no questions, that's okay. I just want to do a quick summation. I said thank you already. Quick summation. Trademarks are important because they help protect your brand. They provide a solid foundation for your brand. A lot of times, underserved entrepreneurs of color, maybe first generation entrepreneurs, don't always have the toolbox that other people have. But intellectual property is important because that's the foundation of your business. You want to make sure you have your business affair, your brand affairs in order. Trademarks are important because they serve as a source indicator. If I go online and I see just do it, I know that's Nike. I know I can trust Nike. So as you're building your business, as you're building your brand, you want your customers to trust you. In the trademark world, we call that goodwill, really building up your reputation. You don't want someone else to come and profit off of all your hard work. Maybe you've been building a brand for 5 years. Maybe you've been building a brand for 6 years, 7 years, and you start to use your brand name, and someone else comes and uses that name, and now people are confused, and they're thinking that second individual is you, and it's not you, and that second individual is not giving the quality that you give, is not giving you the effort that you give, and that's tarnishing your brand. So that's why trademarks are important. Trademarks are important as well because they allow you to monetize your creative ideas. Creative ideas do not come easily to everyone. Creative ideas are worth something. That's why we have intellectual property protections. Protect your brand so you can monetize your idea, so that when you're doing business with others, it also, in a sense, legitimizes your brand, because people can see you take your brand seriously, that you're not, running a business, but you're not engaged in a hobby, but you're running a business. So it helps to legitimize your brand when communicating with others, when communicating with outside agencies, and you have a registered trademark symbol next to your name, that lets them know that you take your brand seriously, that you take yourself seriously, and that you have your affairs in order because you've at least been able to register your brand with the USPTO. And it helps you to stop other people from inappropriately making money off of you. It allows you to control. So we talk about helping to empower, embolden, and educate women how to take charge of their brand. You get to control how what you created is used. If you want to license your trademark to several people, that's a-okay, but you want to make sure that, again, you're protecting the integrity of your brand, you're protecting the quality of your brand, and that you're vetting the individuals to whom you're licensing your trademark rights to. I also call trademarks our intellectual property in general, but particularly trademarks, the great equalizer. It doesn't matter if someone has more money, more resources than you. If you protect your brand, they cannot later on, bulldoze you or run you over and steal your rights. You have your rights in place, and you will be able to protect your rights and defend your rights. They may have deeper pockets, but if you have a brand that's established and have a trademark that has a pretty strong scope of protection, you'll be able to prevent, the so-called Goliaths from coming and trying to steal your ideas, or basically, run over your ideas, bulldoze your ideas, and basically steal your ideas. So that's why trademarks, I believe, are important in a nutshell. If you have any questions, I'm gonna in the later that you think about, I'm gonna put my email in the chat. Feel free to shoot me an email at info@kvllawfirm.com. Follow me on socials. Shoot me a DM. I'm here to help. I'm here to serve. I'm here to reach out for such a time as this. This is a time where a lot of people are building brands. I know in 2020, a lot of brands spiked, but a lot of purpose-driven entrepreneurs are building their brands in this season. So it's important to make sure that you build right, that you have that solid foundation, that you lay a good foundation, a good framework for the brand, so that you'll be able to pass on something to your children, your children, your children, children's children, and leave a legacy. So it was great talking to you. Thank you for joining. Hope to see you next week. Please look out for an email with the replay if you needed the information on the slides. And I hope you have a good night. Thank you so much for coming. I appreciate you guys. Bye.